Welcome to this free presentation from Johnson's Solicitors. Flexible working, what you need to know. This is about changes to the law from the 30th of June 2014. It concerns matters of UK employment law that every employer and every employee should know. Please watch this presentation and share it widely. What is it about? It is about the right of an employee to request flexible working. Who needs to know about it? All employers, all employees, personnel and human resources professionals, unions and of course lawyers. Where is the law? The primary legislation is to be found in the Children and Families Act 2014, Part 9, beginning at Section 131. Under that legislation, there are new Flexible Working Regulations 2014, and the new law amends the Employment Rights Act 1996, Part 8A. As I have said, the changes come into force from the 30th of June 2014. This talk is free because every employer and every employee needs to know about it. That is a lot of people. Please share it. Please share this with everyone you know by email, on Facebook, on Twitter, on LinkedIn, or simply by word of mouth. The key issues. The removal of the restriction of the right to request flexible working to carers. From the 30th of June 2014, any employee can request flexible working. It doesn't matter whether they have caring responsibilities or whatever the reason might be for making the request. Although particular care needs to be taken if the reasons for making the request may give rise to other issues for consideration, such as disability issues. The obligation on the employer is to deal with applications in a reasonable manner. And the new ACAS Code of Guidance provides clarification about the changes to procedures. The old rigid procedure has been abolished, and instead employers are expected to consider the Code of Guidance. With regard to appeals, there is no longer a strict obligation to have an appeal procedure, but it is good practice to do so, and the Code of Guidance recommends this. The role of the Employment Tribunal is still very restricted. So who can request flexible working? Well, obviously, any employee can make a request at any time. There is never anything to prevent an employee from approaching his or her employer and seeking to negotiate a variation in the terms and conditions of employment. However, for the purposes of the legislation and of this short presentation, we are looking at those employees who have worked for the employer for at least 26 weeks. What is flexible working? Job sharing. This is where two, or in theory more people, do one job and split the hours between them. Working from home or from elsewhere, some or all of the working hours. Working reduced hours. This could be working shorter days or fewer days or taking longer breaks. Obviously, pay would be reduced proportionately with any reduction in hours. Working compressed hours. This is where the employee does the same number of hours in a week or a month, but compresses them into fewer days. Flexi-time. This is very common with some public sector employers and also with some private employers. It is often the normal practice in some employments to have flexible working. Here, the total number of hours remains unchanged, but the employee chooses when to start and when to finish each working day within certain agreed limits and usually around certain core hours. So, for example, I might have to work a 35-hour week, approximately 7.5 hours per day, but I might be able to start at any time after 7 a.m. and finish at any time up to 7 p.m. provided that I cover certain basic core hours, which may be 10 a.m. to 4 p.m. Staggered hours. This is where the employee negotiates a different start time, break time or finish time to colleagues. And finally, phased retirement. This is where the employee wants to reduce hours as a chosen retirement date approaches. In essence, there's not much difference between the phased retirement option and the working reduced hours referred to above. How to make and deal with a statutory application. This is a formal application made by an employee with more than 26 weeks service. The employee must make a written application. Obviously, it is sensible if the employee can set out precisely the variation that he or she wants. The employer must consider the request and, unless immediately prepared to agree to the request, the employer should arrange a meeting to discuss the request. The employer should allow the employee to be accompanied by a work colleague or a trade union representative. The employer should consider the benefits of the request for the employer and the employee, as well as any adverse effect on the business. And the employer must inform the employee of the decision as soon as possible. Here, whenever I say must, this is a legal requirement. When I say should, then it is a matter of good practice and recommended under the ACAS Code of Guidance. If the request is accepted or agreed with modifications, then discuss and agree the detail in order to avoid any disputes in the future. Amend any written contract of employment or issue a new contract, taking care to record also the date from which continuity of employment runs. As hours and place of work are two of the things that must be notified in a written statement of particulars of employment under section 1 of the Employment Rights Act 1996, the changes must be notified in writing to the employee within 1 month. If the request is rejected, the employer will only be considered to act reasonably in rejecting the request if it is for one of the following reasons: additional costs, inability to reorganize work amongst existing staff, inability to recruit additional staff, a detrimental impact on the quality of work or production, a detrimental impact on performance, a detrimental effect on ability to meet customer or client demand, insufficient work at times proposed by the employee, inconsistency with a planned structural change to the business. Appealing. If a request is rejected, the employee should be notified of how to appeal against the decision. It is not strictly a legal requirement that there is a right of appeal, but it is good practice and is recommended under the ACAS code. The employer should have a clear and fair procedure for considering appeals. And the whole process, including any decision following an appeal, must be completed within 3 months of the date of the original request, unless an extension is agreed between the employer and the employee. Complaining to an employment tribunal. If a request is rejected without any further right of appeal, or the period of 3 months from the date of the initial request has expired, then an employee can make a complaint. If the employer has failed to deal with the request, refused the request other than on one of the grounds allowed, based the refusal on incorrect facts, or the notification was defective. The tribunal cannot adjudicate on the reasonableness of the rejection per se. This is very important. The employment tribunal cannot put itself in the position of the employer and substitute the decision that it would have made for that of the employer. The employment tribunal is restricted in dealing with matters on the basis set out. What the tribunal can do: the tribunal may make a declaration that a complaint is well-founded. If the tribunal makes such a declaration, then they may order reconsideration of the application, and they may make an award of compensation. This is limited to up to 8 weeks' pay, and there is a cap on the amount of a week's pay that can be taken into account. That is the same cap that is applied when calculating matters such as statutory redundancy pay or compensation for unfair dismissal. That sum is increased annually in accordance with inflation. Issues to be considered. Other possible consequences of failing to consider a request properly or rejecting a request or appeal include a potential claim for discrimination on grounds of disability. If an employee has requested flexible working for reasons connected with his or her own disability, or possibly with the disability of a person for whom they have caring responsibilities, then there may be a potential discrimination claim. A claim for discrimination on grounds of some other protected characteristic. It is always important that employers try to understand the reasons why the employee may be requesting a variation to their terms and conditions of employment. It may not be immediately obvious, but an employee might seek to change their hours in order to avoid exposure to discrimination from another employee. A claim for constructive dismissal. Simply rejecting a request for flexible working is unlikely to amount to a fundamental breach of contract, giving rise to the right to resign and claim constructive dismissal. But if relations are already strained, and if the employee was seeking the variation in order to avoid, for example, exposure to discrimination by a fellow employee, then refusing a reasonable request for flexible working could potentially add to the circumstances that could result in the employee resigning and claiming constructive dismissal. Care should also be taken not to breach the working time regulations when making adjustments to hours. This may be a particular concern if the employee is seeking compressed hours. And remember that the contract or statement of particulars of employment may need to be amended, and the employee will need to be notified accordingly. Best practice. It is clear that employers should develop a clear policy for dealing with flexible working requests. Wise employers will develop policy in consultation with employees so that procedures are agreed and clearly understood. Procedures may be incorporated into or mirror existing procedures for dealing with grievances and appeals. Great care is needed when drafting documents, setting out policies and procedures, and employers should seek expert legal help when doing so. It should be noted that from the 6th of May 2014, the Employment Tribunal will not accept a claim unless the claimant has informed ACAS and can produce a certificate to prove it. See our presentation, Compulsory Early Conciliation via ACAS. Thank you for watching this presentation from Johnson's Solicitors. Please share it with others. You can find other videos on the Joleaf Limited YouTube channel. Once again, thank you for watching this presentation. Please share it widely.